Hello again. This is Tuariki Delamere, former Minister of Immigration for New Zealand, currently a licensed immigration advisor and the principal consultant for DDA Immigration. This is the second of 3 videos discussing various aspects of the Accredited Work Visa application process, which has just come into force. This video discusses the job check application and what employers need to do. So first up, the employer must pay a fee of $610 for every job check application they submit to Immigration New Zealand. Now, an accredited employer who wants to be able to employ non-New Zealand citizens must make a job check application for each specific job type. And only accredited employers can apply for a job check. The job check can be started now because the accreditation started on the 23rd of May, 2022. And from 4th of July, all migrants who want the job must go through this process of applying for an AEWV. Now, all approved jobs are linked to the accredited employer and they cannot be transferred to another employer. They can't even be transferred to another job within the same employer. Non-New Zealand citizens and resident visa holders can apply for an approved job check, AEWV. And you've seen that I've highlighted resident visa holders because this is the actual policy, WA 3.1C. If a job is approved as part of a job check application, a non-New Zealand citizen, agreed, or resident visa holder can apply for an accredited employer work visa. Now, in my opinion, Immigration have got that wrong because it's not possible for a resident visa holder to apply for an accredited employer work visa under current legislation because the resident visa holder already holds a visa and you can't also hold a temporary work visa. So I am writing to the minister to ask him what the heck's happened here. I think they've made a mistake there. Keep you posted in the future. Now, the details of the job offered to the worker must be the same as the job that was ascribed and approved in the job check application. Now, employers with standard accreditation can have a maximum of 5 approved jobs at any one time. For employers with high volume accreditation, there is no maximum number of jobs. And once a job has been approved by Immigration New Zealand, migrants can apply for the Accredited Employer Work Visa, AEWV. And as I said before, the details of the job offered must be the same as approved in the job check application. Employers can't add and detract bits and pieces in the employment offer if it's different from the job check application documents that were provided. Applications must be made using the approved online form. Employers must include the following evidence: a detailed job description, a proposed employment agreement, and a labour market test if it's required for the advertising of the job. Multiple jobs may be included if details are the same for the job. If it's exactly the same job description, you can have multiple, up to 5 if you're a standard, and above 5, of course, if you're high volume. And you must state the occupation location, the minimum guaranteed remuneration, and the maximum remuneration. You must state the type of agreement, whether it's permanent or fixed term, the minimum qualifications that you require, work experience, skills required for the job description, the proposed employment agreement, and the same set of advertising for the jobs. These are conditions that are much tighter than before. And moving on, acceptable employment, the employer must be an accredited employer, and accreditation, as I said, opened on the 23rd of May. And the employer must be the direct employer for the proposed employment. And let's discuss acceptable employment. Remuneration must be at or above the median wage. And the median wage as of today, the 5th of June, it's $27.76 an hour, or the salary equivalent. Employment must be full-time, must be at least 30 guaranteed hours per week. And the terms and conditions must not be less than those of the New Zealand market for that occupation. Remuneration must be by wages or salary. Acceptable employment. Goods or services can be part of remuneration, but only if they are specified in the employment agreement and approved by an immigration officer to be reasonable deductions for these goods and services. The pay period for employees must not be longer than 1 month. And the employer cannot pass on to the employee any recruitment, compulsory training, or equipment costs or fees to the employee. The job can only be for a single accredited employer only. There's one exception, unless that job is for a resident medical officer and the employers are DHBs with high volume accreditation, and the job is covered by one single employment agreement. And if a labour market test is required, the job is advertised as one role, not multiple roles across the different employers. Also, the job that's being offered must not involve the employee being placed in a triangular employment arrangement unless that employer holds high volume accreditation triangular employment. This is, say you're employed by head office and you are required to work for a subsidiary. And all employment must be compliant with New Zealand employment law. Continuing on acceptable employment, the proposed employment must be genuine. You need to convince immigration that it is genuine. And this may seem a bit silly in some cases, but believe you me, over the years, I've seen a lot of employers create rubbish jobs because they're being paid to create that job. So Immigration New Zealand could come back and ask you to demonstrate and prove that it is actually genuine. Now, if the job involves traveling or changing directions as part of the job, or changing locations as part of the job, the terms and conditions of that travel or change of locations must be set out in the employment agreement and not have the potential to disadvantage the employee. Now, most jobs are all at a single location, though over COVID, a lot of people are working from home. If you're going to be working from home at times, that needs to be spelled out in the employment agreement. And of course, changing locations, well, long distance truck drivers, people working for airlines, these are the sort of people that are contemplated in this aspect. So it must be included and described in the employment agreement. Now, in determining possible advantages for the employee, immigration officers may take into account the notice period employees are given when required to change location. And compensation provided to employees when required to travel or change location, including for travel and accommodation, will be taken into account to make sure that the employee is not being unfairly punished or penalized. In the process or outcome, when an employee is unable to change locations or undertake the travel, what does that mean for the employee in terms of continuing the employment? Immigration will look at that as well. Now, jobs under the AEWV, they must not be for self-employment, so you can't set up your own company and employ yourself. You can't set up yourself as a sole trader. And jobs in the horticultural and viticulture industries are not covered in the AEWV. These jobs are covered under the recognised seasonal employer or the supplementary seasonal employment instructions. Now, the evidence that the employer must provide include, but are not limited to, the employment agreement and information about minimum qualifications, work experience, skills, or other required specifications to hold down that job. The mandatory clauses that must be included in the employment agreement: the name of the employer, the job title, a detailed job description, the hours of work, the pay period, and the duration and type of agreement. These must be included. Also, details of pay and conditions of employment, the place of work. And if it's multiple locations, including home, you must spell that out. Include details about paid leave entitlements. And only include clauses that comply with employment law. I've seen agreements where employers have added in clauses that are clearly in breach of employment law. You do that, the job check will fail. You must include the maximum number of hours the employee may be asked to work. And you must spell out the additional overtime rates if they apply for extra hours, details of the overtime rate of pay. Now, the labour market test must be met for all jobs except where the remuneration is $55.52 per hour above. That's double the median wage. And the labour market test is met if the employer has made genuine attempts to attract and recruit suitable New Zealand workers by advertising the job, and the employer did not find suitable and available New Zealand workers for that job. Now, the evidence of advertising. The advertising requirement now is a lot more stringent, if you like, than before. You must include the content of the job, the dates that the ad ran, the duration of the job, of the advertising, and the advertising platform, and a declaration from the employer about whether they found any suitable and available New Zealand workers for the job. Before I continue on this, if you're advertising for a job that you're expected to advertise in a national medium such as Trade Me, Seek, or industry specific, okay? You must target your ad where it realistically will be seen by New Zealanders looking for work in your industry. Now, there are jobs that are exempted from this process, and I'll just go through them quickly. They're in construction and infrastructure. As you can see here, there's the list of them: metal fabricator, welder, fitter welder, painting trades worker, fibrous plasterer, solid plaster, wall and floor tiler. This reflects the great shortage in the construction industry. Also in the care workforce, aged care, residential care, disability care. Kaiawhina, disability service officer, residential care officer, aide to disabled carer, nursing support worker, personal care assistant, therapy aide, and child or youth residential care assistant. On the right-hand side, you'll see the relevant ANZCO codes for those occupations. For those of you who do not know what ANZCO is, stands for the Australia New Zealand Standard Classification of Occupations, which is an agreed description of jobs in both countries. There are about, I think, 10,000 different job occupations in that manual. Now, there are jobs exempted for tourism and hospitality, but these are only exempted from the median wage threshold until April 2023, so about 10 months from now. And this is on the expectation that once the tourism industry picks up, there'll be no need to not be paying the median wage. But again, there's a whole raft of job titles there: hotel managers, motel managers, accommodation hospitality managers, licensed club manager, conference event organizer, travel consultant, travel agency manager, tour guide, caravan park and camping ground manager, diving instructor, hunting guide, gallery or museum technician, trekking guide, waiter, commercial housekeeper, kitchen hand, barista, hotel or motel receptionist, bar attendant, fast food cook, food trades assistants. Hospitality workers, cafe workers, pastry cooks, assistant, door person or luggage porter, gaming worker, travel attendants. It's quite clear that Immigration New Zealand have tried to cover just about every occupation they can think of that comes within the tourism and hospitality industry. So that's trying to help them out, because this is one industry that has suffered terribly through COVID. Now, the genuine attempts to attract New Zealanders by advertising. The jobs must have been advertised on general national job listing websites such as TradeMe or Seek, in the New Zealand Herald, though I'm not sure why anyone would do that these days. No one reads the ads, I don't think. Or by other means, such as an industry-specific job listing website, which some industries have. Now, the job advert must have been listed for at least 14 days. It must have closed prior to the job application being submitted. So you can't submit the job application while the ad is still running. And the end date of the advertising must be within 90 days prior to the job check application being submitted. So once you've closed the ad, you've got 90 days to apply for the job check application. If you don't apply within the 90 days, you're gonna have to run the ad again. Now, the ad must include a job description detailing the key tasks and responsibilities and the key terms and conditions of the employment, including minimum, maximum wage rate of salary or wages, the estimated earnings, where a significant portion of the actual earnings are not guaranteed, the minimum guaranteed hours of work, the location of the job, and the minimum qualifications, work experience, skills, or other specifications required for the job. These must all be included in that advert. If you don't, your job check application will fail. Now, this is a lot greater detail than you ever see in job ads on TradeMe and Seek. But if you are doing this because you want to employ someone under the AEWV Accredited Employer conditions, you must have all that information there. So if you don't, you won't get approved for the job check. You must also include the minimum qualifications, work experience, skills, or other specifications required for the job, but you must only include those requirements that are necessary to perform the work on offer. Okay, you can't tailor your ad to, for example, try and exclude every other person on the planet except the person you've already decided to give the job to. If you do ads like that, you will fail the job check. And the ad must be the same as those stated in the, must include information as same as stated in the application form. Okay. Now, determining whether the minimum requirements are met. An immigration officer may use ANSCO, the Australian New Zealand Standard Classification of Occupations, to determine whether the minimum specifications identified by the employer for the job are necessary. And where a job is not described in ANSCO, an INZ officer may make a personal assessment of whether the minimum requirements are reasonably necessary, taking into account such factors as the roles and responsibilities of the job, whether the specification is likely to result in suitable and available New Zealanders not applying for the job. Okay, so if you're trying to write your job spec to fit someone you've already decided to give the job to, you need to be very careful because immigration will be on the lookout for that. Examples: unacceptable, requiring foreign language skills for a cafe or restaurant worker job. This has been a common requirement that many cafes, restaurants have used so they can employ just workers from their home country, where the employer has come from a particular country and they only want to employ people who speak the same native language. You do that, your job check will fail. There is no reason that an Indian restaurant must have a Hindi, you must speak Hindi or Punjabi, or a Chinese restaurant, you must speak Mandarin or Cantonese. If you put that in your requirement, you won't be approved. Acceptable foreign language skills, though, could be for a job such as a tour guide, catering for non-English speaking tourists. Having fluency in the foreign language may be necessary to perform the work on offer. So if you work for a Chinese tour company that specializes in Chinese tourists, then it's quite reasonable and acceptable to require the tour guide to speak either Mandarin and or Cantonese, or Japanese for Japanese tourists, etc. You cannot require a driver's license or a vehicle license, cannot be a minimum requirement for the job, unless operating a vehicle is necessary to perform the work on offer. okay? If you require the employee to have a vehicle, you must also make sure that it is required for the job, but that the employee is compensated fairly and reasonably for that vehicle, the use of it. Being able to commute to the workplace is not part of performing the work on offer. So requiring a driver, license, or vehicle for this purpose is not acceptable. Employers holding standard accreditation. A job check application for an employer holding standard accreditation will not be approved if it results in more than 5 jobs being associated to the employer. Okay, because standard accreditation means a maximum of 5. If you want to go more than 5, you have to apply to be upgraded to high volume, 6 or more. Calculating remuneration. This is important because they're going to calculate, are you offering at least the median wage? And so you must meet the minimum pay required. The remuneration is calculated on the basis of guaranteed payment per hour. Okay, so you can't include things like commissions and bonuses because they're not guaranteed. The only thing that the Immigration Department will consider is guaranteed payment per hour. And the average guaranteed remuneration for each hour of work must be at or above that threshold, which is currently $27.72, I think it is. Remuneration is calculated according to the hours of work stated in the job check application and must be the same as the proposed employment agreement. Any salary will be calculated down to the number of hours that will be worked each week. Okay, so if the income is specified in salary, the immigration officer will take that salary and calculate it down to the number of hours that are worked per week, and then the hourly rate will then be calculated because you've got to not only meet the 27.72, you must meet the 30 hours per week minimum. Where the remuneration cannot be confirmed because it's within a range, the calculation by immigration will be based on the lowest rate in that range. So setting a range of, say, $25 to $30 an hour, immigration is going to base it on $25 an hour, and you will fail. Variable hours. And many jobs, the nature of the job is variable, like truck drivers. The hours of work per week are considered variable where the employment agreement allows the employer to request or require the employee to work additional hours from time to time. Where the employment agreement specifies payment other than by hour, INZ may request evidence of the range of hours to be worked, including the maximum for calculating the remuneration of the employment. And where the job check application or employment agreement specifies a range of hours, remuneration is calculated using the maximum hours. And when that's done, this will almost certainly reduce the calculated hourly rate. And if it goes below 27.72, your job check application fails. Now, overnight hours, which is very important in jobs for aged, residential, and disability care, where employment requires the employee to work overnight, but allows them to sleep during this time, any hours spent sleeping may be excluded from the hourly rate calculation, provided that for the hours the employee is sleeping, they must be paid at or above the minimum wage. Okay, you just can't let them sleep and not be paid. They must be paid at the minimum wage for those sleeping hours. And for any hours the employee is required to perform duties, they are paid at least their normal rate, which means if they have to get up during the night to attend to something, they need to be paid at their normal rate, not the sleeping rate. And the employee must be guaranteed a minimum of 30 hours per week at the normal rate. You can't make up their 30 hours by including their sleeping hours. And this is only for employment in the aged, residential care or disability care industry. They determine the location of the job. It's where the employee works entirely or mainly carries out or based for their employment based, and that should be stated in the employment agreement. and should be the same as provided in the job check application. But if the work is to be performed in more than one location, INZ may determine that the job is therefore located in multiple locations. And this brings in other aspects, especially with the labour market test. And the location is based on regions, based on regional council boundaries, and cities are based on city council boundaries. And Immigration New Zealand may request further evidence to help them determine where the job is located. And as I said, the reason for doing this is because there are additional things to meet in terms of the labour market test. Now, processing verification requirements. If Immigration New Zealand suspect that an employer no longer meets their accreditation requirements, Immigration New Zealand may postpone making a decision on the job check application until INZ is satisfied the employer meets the requirements or the employer's accreditation is suspended. They won't just stop it automatically, but if they suspect something may be wrong, then they can suspend the processing of the job check application until they verify the employer's status in terms of are they continuing to meet their accreditation requirements. And so if the accreditation is suspended, Immigration New Zealand will almost certainly postpone making a decision on the job check application until the suspension ends. And if the accreditation then expires or is revoked, Immigration New Zealand, well, I say may decline, they will decline the job check application. They don't have any choice. Now, if the employer's accreditation is suspended, Immigration New Zealand are most likely going to postpone the decision on the job check application until the suspension ends. If the employer accreditation expires and revoked or is revoked, INZ may decline the job check application. INZ may decline a job check application if they are satisfied that the employer provided false or misleading information in support of the application or withheld relevant information that was prejudicial to approval of the application. And to verify that information in the application is genuine, accurate, and true, INZ may request evidence from employers, migrant employees, and other parties such as government agencies to determine if employer meets job check requirements. However, in my opinion, the right to verify does not allow Immigration New Zealand or the employer to breach provisions of the Privacy Act 2020. Demanding information such as a copy of the payroll records and personal details of all employees is prohibited under the Privacy Act 2020. And in my opinion, employers will be breaching the Privacy Act 2020 if they provided such personal information of employees to Immigration New Zealand. And in my opinion, it's also illegal for Immigration New Zealand to ask for such information. I mention this because over the years, there's been continued action by Immigration New Zealand officers to demand such information. And in the end, I've always won that argument because it is illegal for employers to provide such information and illegal for Immigration New Zealand to ask for it. Now, I don't know whether they will do this, but this is just put in there to remind everyone to be on the lookout for that. Now, when considering a job check application, immigration officers must follow the principles of fairness and natural justice for employers when assessing a job check application. This means if Immigration New Zealand have concerns, the employer must be given the opportunity to comment before a decision to decline an application is made on the basis of any potentially prejudicial information. If an application fails to meet the job check requirements, INZ may waive specific requirements after considering all the circumstances of the application, the objectives of the Accredited Employer Work Visa policy, and the situation of the employer. Now, this is a sensible thing to have because some employers may find themselves getting into trouble on this, but they're a large, genuine organization without any bad records, but they can make a mess up here. And their work that they do is critical for New Zealand. You know, for example, the aged care employers, hospital boards, the airlines, many big corporates occasionally make unintended errors in the areas of immigration law, employment law. So where the application does fail to meet the job check requirements, it's not necessarily an automatic decline, and Immigration New Zealand could waive those requirements if it's appropriate. I mean, such decision must be approved by an authorized immigration manager or higher, all the way up to the minister. Currency and approval specifications. Job checks are approved for a duration of 6 months. Okay, that's it, 6 months. After that, you've got to reapply. If the employer's accreditation is suspended, current job checks are also suspended. An approved job check will specify the occupation, the minimum and maximum remuneration for the employment, the location of the employment, the number of jobs approved, the job check start date, and the job check expiry date, which, as I said, will be 6 months later. Now, this is the actual instruction. When a job is WA 3.50.5A, when a job is approved as part of a job check application and is associated to the employer, a non-New Zealand citizen or resident visa holder can use it to apply for an accredited employer work visa. And again, as I mentioned at the beginning, I've highlighted resident visa holder because it's not legally possible for a resident visa holder to apply for an accredited employer work visa. You can't hold two visas. You can't hold a resident visa and a temporary visa at the same time. The law does not allow that. So I am writing to the minister to ask him, hey, Chris, what happened? I think someone's got something wrong somewhere. Now, the job token. Once the job check is approved, the employer is given a job token that has a unique number linking the migrant's application with the approved job check. The employer must give the migrant the job token number, must give him a copy of the employment agreement and a signed offer of employment. The token is for one-time use only. You can't use it for multiple applications. And if the job token has already been used and a visa granted, that token is now finished. Now, reconsideration process. If the job check application is declined, there's no statutory right of appeal against the decision to decline a job check application. However, Immigration New Zealand may reconsider a job check application where the reconsideration request is made within 14 calendar days of the date of decision on the application. If you wish to do that, there's a $240 fee. Well, look, I hope this video has been useful and informative. Like I said in video 1, this is not a simple rubber stamp automatic process. It is complex, it's complicated, it's much more detailed and puts a lot more demands on employers than before. And it's all designed, quite appropriately in my opinion, to hunt down and get rid of those predator employers who are exploiting migrants. If you are an open, honest, and transparent employer, you'll have no problem getting through, but it will take time, because I said it's a lot more complex and complicated and puts a lot more work on the table for you to do to get there. But I think overall, I have a great reputation for getting stuck into my old department, because, you know, when I was minister, you're supposed to stand up for your department. And as soon as I left being Minister of Immigration many years ago, my job was then to fight them. But look, I think Immigration New Zealand, the government, have done a pretty good job. Yeah, it's bedding in. Things will pop up from now and then. As I said, those wordings of resident visa holders is an obvious, to me anyway, oversight cock-up, if you like, which we easily fixed. So look, as I say always, stay safe. Make sure you protect yourselves from COVID, get your shots, and hopefully COVID is behind us. So the next video is for the applicants and what they must do once you, the employer, have got your job check application approved. Kia ora mai koutou on Queen's birthday weekend.